Hey guys, this is Christopher Rubio. I'm here with
Dan Hales.
All right. Well, Dan, I just got this question that came up. It's about transferring title and what's that process look like? Who do we talk to when we're changing, our property title from, let's just say, one person to the living trust? Do you have any kind of recommendations or want to talk a little bit about that process to help everybody out there?
Yeah, sure. What you're talking about really is trust funding, which gets back to the basic concept of when you create a trust, in the beginning it's empty. So then you have to put things into it. And whatever you put into it, it's going to be protected from probate. So with respect to real property, when you have a trust, you have to transfer the real property into the trust. And transferring property must be done in writing, and it must be done by a deed. So depending on the state where you live, it's either a grant deed or a warranty deed typically, or sometimes a quitclaim deed. But that deed has to be prepared and signed in front of a notary public. So typically it's going to be stamped, then it's going to get mailed into the county recorder. The recorder is going to look at it, and they're going to stamp it. The county's going to put the stamp of the recordation stamp and a document number up, and usually up in the right-hand corner, and then they mail the completed recorded deed back to you. And when you get it back in the mail, then you know that your deed was recorded. And then it's officially in the trust. Because the deed will say something like, I, Matt Jones, an unmarried man, grant to Matt Jones, trustee of the Matt Jones Living Trust, dated July 4th, 2023, for example. So the trust name is actually going to be on the deed. That gets recorded with the county, and then you've done it.
Well, yeah, and that's great. So a lot of people, Dan, they say when that happens, I'm worried that my property tax is going to be reset, or maybe I bought it at such a low price, my tax rate is low, my tax base. Can you talk a little bit about that and ease any concerns for people out there?
Yeah, sure. Because there's no change in ownership. You're the owner before the transfer, and you're the owner through your living trust after the transfer. So therefore the owner is the same. It's still you, and therefore there's no change in beneficial ownership, and therefore there is no reassessment of the property taxes. And the property taxes will stay low, if they were low, or they'll stay wherever they were at the time of the transfer. And most counties have a special form you have to fill out. You have to tell the county that, yeah, I'm the same guy or girl or couple, we're the same owners before and after the transfer. Most counties have their own tax exemption form, and you have to fill that out and submit that with the deed to let the county know that this transfer is not happening as a result of some sort of a sale or third-party transfer. It's just you changing the way you hold title to your property and putting it in the living trust. So there won't be any adverse consequences. And another concern that comes up, people sometimes ask, well, if I put my house in the living trust, will it trigger the loan? Will it cause my mortgage to become due? Yep. And the answer to that is also no. States have laws that say that if you have a living trust, the simple act of funding your property into your trust will not trigger the loan to be called due, as it would be called due if you were selling to a third party, for example, right? So yeah, property taxes don't change, your mortgage won't change, but the title on the deed needs to change, and it needs to have the name of your living trust on it.
So Dan, correct me if I'm wrong, we have a copy of our living trust. Does that need to go to the county, or what's kind of that process along when you're filling these documents out for the recorder's office?
No, not unless the county asks for it.
Okay.
All the county wants to know on the face of the deed is what's the name and date of the trust and who the trustees are. They're going to kind of take your word for it that you actually have a trust document, and they're not going to ask to see that document unless there's some sort of a reason for it. But that's pretty rare. Sometimes, for example, somebody might have a special name of a trust that's not their name. Instead of saying the Tom Jones Trust, maybe the trust says the Red, White, and Blue Trust. And it's not obviously your living trust. It could be anybody's trust.
Oh, that makes sense.
And so when the name of the trust, when the name of living trust doesn't match your name as the prior owner of the home, the county might ask to see a copy of the trust just to verify that, the Red, White, and Blue Trust is really Chris Rubio. That's really the only time they're ever going to ask to see a copy of the trust. And the trust won't be recorded, of course. The trust stays private. That's the whole idea of a living trust, is to keep your business private.
So it sounds like the steps are pretty easy. You can go, get your trust done. You can also get it done online with Modern Trust. Go ahead and request the documents from the county recorder to transfer it, get it notarized, and then fill out the application and done. Is there anything that we should add to that process or be concerned about?
Yeah, it's just get the living trust done and then create the deed. There's going to be a grant or warranty deed that needs to be professionally prepared by our office or an attorney or an escrow company, and that document's going to be recorded with the county before the transfer is considered done. So a lot of people miss that step, but if you haven't transferred your home into the trust, then it's not in there and it could still go through probate.
And when you're getting this deed notarized, do you recommend more than one copy just in case the county recorder loses it? I guess what happens in that process?
I mean, usually you get a copy of the deed that's recorded and just keep a photocopy. That's good enough. There's nothing wrong with getting a second original duplicate also notarized. You can keep it in your records, so if the county actually loses your check for the recording fee and they lose the deed, you got a backup deed you can send in. So there's nothing wrong with that.
Well, great. Well, thanks, Dan, for all your advice.
Sure. Easy question, Chris. Thanks for the easy one.